if you specifically waive your right to do so. Without that, that's not a convenience for you over there. It's, you go over there when you frankly demand removal under Illinois versus
I
Allen.
didn't demand anything.
No, your conduct did. So you
My
can
conduct
sit.
didn't demand anything either.
Right, Mr. Brooks,
You
please
keep
sit
changing-
down.
You keep
And
changing
I'm
the
going to continue
jurisdiction.
with my sentencing remarks.
You keep changing the jurisdiction. It's subject matter jurisdiction that has yet to be proven on the record. In
Mr.
that court
Brooks?
and in this one.
Please sit down.
I would like to go back to the other court.
It's not a courtesy to you. If you'd like to specifically waive your right to be physically present, then I will entertain that. Otherwise, you need to sit
I
down.
never waived the right to not be present.
That's
I
because
had
you
to-
forfeited your right
I
to be
didn't
present
forfeit
by
anything, Your
conduct.
Honor.
You're
I
now
wrote-
back in this courtroom.
Your Honor, I wrote 3. I did what you asked me to do.
You
said,
never once pledged to me, sir, that
No.
you would not interrupt, and
You-
you're demonstrating by being here that you continue to interrupt.
Man, I ain't trying to hear all that because at the end of the day, I did what you asked me to do. You told the bailiff to tell me.
Mr. Brooks, this is not a debate.
You told the bailiff to
It's
tell me
not
that
a
I had
debate.
to
You
write.
asked to come over here, and I honored that,
Well,
and
I
I brought you
exercised my
back.
right 3 times. I shouldn't have had to do it 3 times.
None of those opportunities that you wrote to me said, I pledge to not interrupt.
I never had to
Judge
do
Doro."
that before. You've never required that before.
That is actually not true, sir.
You've never required that before. Every single time that I've been brought over there, after some time, sometimes very short, sometimes an extended
Mr.
period
Brooks,
of time.
you are just simply trying to delay the
I'm-
inevitable. Please sit
I
down.
don't care about the inevitable. It was
I need
already
to
written
get
from day
through
one
this
what was going to
hearing.
happen. It doesn't make me lose any sleep about that. I know I'm okay. I'm okay with everything.
Then please sit down.
I just want to be treated fairly, which I have
Please.
not been.
Please sit down.
And then Your Honor, and then you
Mr.
always make it seem
this is
like
not a
you always
debate.
make it seem like it's some type of aim, and it's not.
Please sit down.
We're talking about constitutional rights. You just told me, or you told the bailiff to tell me that I had to exercise a right that I should already have. I did that. Not once, not twice, 3 times. And it still wasn't honored. And then I raised this sign. I'm
Mr.
waving
Brooks,
this for like 20 minutes,
You're-
saying I would want to come back. I'm doing this.
You're
Hey,
here now.
Can I come back? Can I come back? Can I
So
come
sit
back?
down.
It wasn't honored. And then
So I
I said,
can
okay,
finish.
I'll write this and I'll see if Your Honor can see it on the screen. The objection sign saying,
Mr.
I've
Brooks,
exercised my right
if
to
you
be present.
stop for a
May I have
minute,
the order of the court?
I'll explain it, but you have to stop so I can explain it.
Your Honor, I did what you asked me to do.
Actually not.
Yes.
Let me explain
And
if you would like.
If I didn't, Your Honor, if I did not do what you asked me to do, then why was I allowed to come back if I did not do what you asked me to do?
Because I'm frankly going to a very distinct portion of this hearing where I am going to impose sentence.
Okay, that doesn't
and
answer the
that
question, though, Your Honor.
matters.
That doesn't answer the question.
Please sit down
Wait.
and I will explain and
Your Honor,
remain quiet
with all
without
due-
interrupting me.
With all due respect.
That doesn't mean you're respecting me, so please sit down.
With all due respect, you told the bailiff, when I first said, because every time that I've been brought over there in the past,
Mr. Brooks,
you always stated.
I don't need a history
you always
lesson of
stated
what I've done.
that when I exercise my right to be present.
Untrue.
You've
Untrue.
always said, we
Untrue.
have the record. We have the record. We can dig into the record.
Mr. Brooks,
I know what the requirement was of me going over there. You've always stated on the record that when I exercise my right to be present, you will bring me back if I will follow the rules of decorum. That's your exact words, which you said every time.
which you're
I've never-
demonstrating
I've
right now
never
that
had-
you have
Your
absolutely no
Honor,
ability to do.
With all due respect, I've never had to go through any type of certain words that needed to be said or stressed or anything like that before. I've always done it the way that you've asked me to do it. No different than today when I told the bailiff I would like to be present. You told the bailiff if he wants to be present, he has to put it in writing.
And pledge
I
to
put it-
me
I
that
put
he
it
will
in-
not interrupt me
I put it in writing.
without a pledge.
So why am I here?
because I'm going to move on to another phase of this hearing, and I thought it important that you be here in person.
So I was here.
But you didn't reclaim your right to be back here.
Then why am I here
am
then, Your Honor?
allowing it to
Okay,
happen.
and I respect that you're allowing it, but still, it doesn't answer the question, though, Your Honor. It does not answer the question.
Mr. Brooks.
Your Honor, as a public
Brooks.
servant, I have the right to ask questions
Sir,
of Your Honor.
I'm going to ask you one more time, and if you refuse to sit down, then you are in direct disobedience of a court order. Sit down and be quiet so I can make the appropriate record.
Can you tell me what the
All right,
court order
he's
is?
not going to obey. He's now forfeited
I
his
didn't say
right
I
to be
wasn't gonna
present.
obey.
He will go into the
I
other
didn't say I
courtroom.
wasn't going to obey.
We'll be in
I just asked
recess
what is the
until he's
order.
there.
I just asked what is the order. I didn't say.
Damn, I missed the beginning of this.
Ladies and gentlemen, we thank you for watching our channel, The Joey Nugg Show. Feel free, if you want to support our channel, hit our Cash App up at $Joey Nuggs. Thank you. We're waiting for Mr. Brooks to once again leave the courtroom and go to the other courtroom. They have a back courtroom. It's like the penalty box they drop them into. So in the meanwhile, we will wait for court to proceed. We're getting to the end of the part of the sentencing where she's getting ready to read the sentence to him and tell him how.
I bet you she lets him in again.
You think?
Yeah, she's gonna let him in like during the middle of the counts.
We'll see.
I think she's just trying to show how he's not gonna change, and after all this, like you're not mentally ill, how he still went back to that shit. They have to like keep proving their points the whole way.
He knows what he's doing. There ain't nothing mentally ill about him. Everything along the way knew that he knew exactly what he's doing.
Yeah,
he wouldn't have changed his appearance. He wouldn't have tried to hide who he was. He wouldn't have been calling in and trying to get a ride home for mama on an Uber. All that if he didn't care about who he was. He knew what he was doing through all of it.
Yep.
This is his last moment in the spotlight.
I thought the judge was gonna go easy on him.
Hollywood is not going to be in his future. He's looking at 3 hots and a cot in a long time. Did you think about what he's doing? We're seeing the flag shook a little bit there. Maybe they're going to come back here in a moment.
So somebody walked by it.
I don't know. I saw it shake. I know that.
I heard something too.
We'll see. It's been very unique, ladies and gentlemen. I even took my hat off because I've been over here watching the sentencing for a minute here. You put me back on here. Took the chain off, and I'm over here eating some California raisins. I'd ate a pound of popcorn if I'd ate that during this day. Good Lord.
Hearing a bunch of courtroom noises.
All right, I'm ready to get a real meal. We didn't even break for lunch today. It just kept going and kept going, huh?
I haven't ate either.
No, we haven't broke for lunch at all. Think about any time during the trial today. Has she broke for lunch? No.
She's trying to get through it, and he's making it hard.
Yeah, he's trying to have another day in the sun because every day that he can argue in court is one less day. Here he's back here. Here we go. We're back. Once again, this is the Joey Nugg Show. If you like our channel, feel free to send us something on our Cash App, $Joey Nuggs. Another selfish plugs by yours truly, Joey Nuggs. Come on, Judge, bring the heat. Burn this son of a gun down. Some of that fish grease.
Please be seated.
Here we go.
He's not sitting down. He's still disobeying the court even in there.
Of course, he always does that. He's going to be a rebel to the
Of course, I do
outlaw
need
to
to
the end.
first verify that they can hear and see us. I'm getting the thumbs up. We are back on the record. The record
at those
reflects
big
that Mr.
sheriffs.
Brooks is no longer
thump
in
his
the
little
main
ass, he
courtroom.
gets out of
He's in
line.
the adjoining courtroom.
I've been hoping they
I,
choke
of
slam
course,
his
have
ass the
been
whole
erring
time.
on the
I'm
side
waiting
of
for him to get out of line and get a
caution,
good
but I
get
would
yanked
note that his
up.
right
It
to
ain't
be
happened
present
yet.
at sentencing is a statutory right.
I'll let her talk.
Which frankly, I probably don't need to go through the findings under Illinois versus Allen. But I did, but under whether it's a statutory right or a constitutional right, you can forfeit that right, and his behavior today has certainly demonstrated that he has forfeited his right to be present in this courtroom during my sentencing remarks. He immediately came in. I was on the bench looking through my paperwork. The courtroom wasn't even open. And he started asking me questions. I said I wasn't going to answer them. He really had no respect for the proper decorum. I needed it to be on the record. He didn't seem to care about that. Wanted to debate me about my prior rulings. Bottom line is, it's a statutory right for him to be present, and he's forfeited that right. And I would just add that it's part of a pattern that has been demonstrated during this trial, that when my perspective, things are not going in his direction, things are being said that he doesn't agree with, that he tends to act out, he disrupts, and I'll leave it at that. Once again, I'll confirm he can hear and see. We've got confirmation from the staff in the other courtroom. One of the reasons I really spent the time going through both my observations of Mr. Brooks in terms of the mental health related issues, and first, and then going through the victim impact statements before I go through all of the necessary factors for sentencing, is frankly, it's challenging to talk about the impact to the victims without getting emotional. This trial is unlike anything that I've ever been a part of. The sheer magnitude of the crime, the number of people impacted, how they were impacted, the vicious, senseless nature of it, and hearing about the impact of all of that on our community members and the people who were at the parade, it's heart-wrenching. And I wanted to do that before I really got to the meat of sentencing, because I also thought it was important to really spend some time recognizing and acknowledging the impact to the direct victims who are in this courtroom and who have provided statements. Today, my focus in sentencing will be about November 21 of 2021, the events shortly before that or leading up to it and after, and are not about Mr. Brooks's conduct during this trial, even though case law is very clear that his conduct at trial can and is a legitimate factor for the court to consider. I need to make the record very clear that in no way what I do here today is based on Mr. Brooks exercising his right to a trial. That is a firmly embedded constitutional right, which I support, which I upheld. Of course, every person charged with a crime has a right to a trial. This court honored that right. I protected that right, even if Mr. Brooks treated it with contempt, disrespect, and at times like a game. But sentencing today is directly related to his conduct on November 21 of 2021 and the other sentencing factors, which, as I indicated previously, include the seriousness of the offense, the need to protect the public, and his character and rehabilitative needs. Today, I am tasked with sentencing Darrell Brooks for 76 counts related to a couple of moments in time. Moments that are tragic, moments that were frankly avoidable. My sentence here today is, the purposes of it are twofold. Really threefold if we think about the community. One, it is punishment. Two, protection of the community. And three, what I hope is justice and closure for the families and the community at large. I, of course, want to recognize and give due respect to the guilty verdicts that were rendered by the jury in this case. Not just 76 guilty verdicts, but the special verdict questions that they answered, including for counts 1 through 6 and 7 through 67, that had the special verdict question related to the use of a dangerous weapon. So let me talk about the seriousness of this offense. The seriousness of the offense can be summed up, frankly, in one word, and that is attack. There is nothing, no other word that can best describe what happened on November 21 of 2021 than the word attack. I talked about, during my remarks regarding the trial, about the opportunities that Darrell Brooks had to avoid this altogether. I put Exhibit 15 on the screen for a bit, which is the exhibit that details the map. The map of the parade. It starts with White Rock. It shows where Sergeant Warner was at one point, farther up that parade route, the staging area, and I believe if you look further up on Exhibit 15, it even depicts where White Rock School is, and that, of course, is where we saw the video of the altercation between Mr. Brooks, Corey Runkle, Nicholas Kirby, and Erica Patterson. Now, of course, there were moments in time before that, but that is really where things started, where I believe Mr. Brooks boiled over with rage and anger that he chose not to control on this date. He had a number of opportunities to simply drive in the other direction down White Rock, but he chose to drive toward Main Street, even though from the testimony we know it was very evident that it was staging for a parade. There were many people, may not have been exactly by the school, but farther down White Rock. From Niagara forward is where that staging area was located, and many people were there. The sights and sounds of a parade, the signs on the side of the road telling people not to park there, for example. Instead of turning around, or instead of turning left onto East Main Street or left onto Pleasant, and despite Sergeant Warner trying to flag him down and being in front of a squad with lights, right, a clear indication you should listen to or honor the even gestures of a police officer, and he was in uniform. He drives down White Rock Avenue and has contact with Detective Casey, who very clearly did everything he could to stop Mr. Brooks. And in that moment, thinking it's a lost motorist. But Mr. Brooks chose to basically brush him aside with that SUV and drive on to Main Street, past more people, past many spectators, and in a manner that was not just at a speed inappropriate for a parade, but frankly, that was reckless and endangered anyone who was on the roadway at that time, whether or not he hit anyone between White Rock and Main and Barstow and Main. But during that 3-block section of Main Street, he could have turned off Buckley, Northeast Avenue, Martin Street, or in either direction on Barstow. He could have stopped, asked for the police barricades to have been removed, or frankly turned his car around even at that point and gone back the way that he had come. But he didn't do that. He chose to drive recklessly, carelessly, and maliciously through a parade route and at anyone in his path, where he struck not one, not two, not three, but 68 different people. We actually know that number's higher because we now know, we heard from the two individuals who were with Extreme Dance, the one girl who was struck by one of the individuals who was clearly struck, and that person flew into her. That would qualify for a charge based upon the state's description of how they chose to charge. It's just they didn't know until closer to the sentencing hearing. So 69 individuals if you include her. There are so many aggravating factors here, it's frankly difficult to even keep track of them all. The complete disregard for the lives of anyone else that day. Someone described it as depraved indifference, and I think that is the perfect phrase to capture the actions of Mr. Brooks on November 21st of 2021. The aggravated factors of the numerous opportunities to turn around or not even enter the parade route or simply to stop. The fact that he mowed over and used that vehicle as a battering ram to hit 68 individuals, never once stopping, with rage and anger at unsuspecting people at a parade who were there simply to kick off the holiday season, to experience joy with their families. The intentionality of the conduct is outstanding. The viciousness, the speed, the swerving from side to side at various points. This was not a case of whodunit. From the very beginning, from when this case was charged, it was clear who did this. Now, that is not to say that I prejudged this case. I did not. But after sitting through this trial, after watching the many videos, after listening to the testimony of the many, many dozens of witnesses, it is clear the state had overwhelming evidence of Mr. Brooks's guilt. What's also aggravated is his complete and utter lack of remorse. He spoke here today for 2 hours. One sentence, that's it. I'm sorry. No detail. 2 hours, one sentence. No empathy for any of these individuals, at times mocking them with hand gestures or rolling his eyes multiple times, that is not an indication or a sign of someone who has empathy, who is sorry for what he has done. We may never know the true why, but we were provided with nothing here today other than a feeble attempt to blame mental health, which frankly does a disservice to those who truly suffer from mental health issues. I understand why his family might cling to that because of the difficulty in coming to grips with a loved one doing such heinous things. But for Mr. Brooks, it's nothing more than indifference, deflection, and outright denial of what he did and the impact that he has caused as a result of his heinous actions. I searched for a mitigating factor in this case. I waited patiently for an apology, a true apology. I didn't get it. And not for my benefit, but for the victims. The law allows me to look at things such as Mr. Brooks's prior criminal history, including the history of criminal offenses and pending charges, the history of undesirable behavior patterns, which can include dismissed, uncharged, or unproven offenses or facts, even including expunged offenses not really relevant here, acts resulting in probation revocation. Of course, those are part of his criminal history, nothing specific to these charges. I can look at his personality, character, and social traits, the vicious or aggravated nature of the crimes, the degree of his culpability, his demeanor at trial and truthfulness, his age, his educational background and employment record, his remorse, repentance, and cooperativeness, his need for close rehabilitative control, the rights of the public, the recommendations of the interested parties, including victims and family members of homicide victims. I can consider statements made by his own family. I can certainly consider the length of pretrial detention, which I'd note, though, when facing 6 life sentences, is really a fraction of the time available to this court. The loss of life in this case is certainly one of the aggravating factors here today. The number of people injured, also an aggravating factor. The reach into the community, certainly palpable because this was a Christmas parade. I think it was a comment earlier, either today or yesterday, that this was not like one act where Mr. Brooks drove into a crowd of people. This was sustained driving from block to block to block to block, picking off people that were unsuspecting. 68, 69 times. driving over people as if they were nothing more than speed bumps. What's also aggravated is his conduct after he drove through the parade. Crashing his vehicle in an attempt to flee. It's pretty evident based upon the evidence and testimony from trial that Mr. Brooks had no idea there were these logs in that backyard that could damage his vehicle. He was attempting to flee when he ran over them, and it ultimately disabled that vehicle, and he was forced to abandon it. He ditched it, leaving personal identification information in it and his phone in a clear attempt to get out of there in a hurry. And then we have that series of videos that we saw at trial of him going through backyards, coming in contact with people, asking to use phones, ultimately ending up at Mr. Ryder's home, who graciously took him in. Never once, Mr. Brooks showing any signs of distress, of any emotion of what he had just done. Cool, calm, collected. Certainly not a sign of someone who had any remorse for what he had just done. Someone who's involved in an accident, even a tragic accident, one where they flee the scene and are later caught, oftentimes show incredible remorse, tears. Not tears for themselves, but tears for what they've caused. A recognition of the loss of life, for example, from their conduct. Nothing. An individual who simply wanted to flee. That is the epitome of consciousness of guilt evidence. Fleeing, changing your appearance, taking off the sweatshirt, not even caring that your shoes are off your feet because you're so intent on fleeing the area. Putting your hair up from it being down. No doubt, this is by far and away one of the most aggravated cases I've ever presided over. The sheer magnitude of the loss, the number of victims, the types of crimes for which the jury has convicted him. 6 counts of intentional homicide, 61 counts of first-degree recklessly endangering safety, 6 counts of hit and run, 2 counts of felony bail jumping, 1 count of misdemeanor battery. What's further aggravated is the fact that he was out on bond. He should have had no contact with Erica Patterson. But the rules mean nothing to Mr. Brooks. Nothing. He didn't care. This was someone who on two prior occasions, charged with, frankly, causing mayhem. One, a reckless endangering safety for discharging a firearm. The other for battering and then running over Erica Patterson's foot. This court does get to consider the other act's evidence that the state sought to introduce at trial. That other act's evidence includes that on November 2 of 2021, Milwaukee police took a complaint from Erica Patterson that Mr. Brooks had run over her with his vehicle and tried to kill her. She had tire marks on her right pant leg. She could not move her leg and had blood coming from her mouth. On that date, Mr. Brooks was driving the same vehicle that he drove through the parade. Erica Patterson was conveyed to Frederick Memorial Hospital. Her injuries received medical attention. She even had that boot on her leg on November 21 of 2021. She described Mr. Brooks to police as yelling at her, using profanity, as she tried walking past him when she was at a gas station. I think initially before that, at another location, but ultimately where he allegedly ran over her was at a gas station and caused the injury to her leg. Struck her in the face once with a closed fist, causing pain and bleeding without her consent. And then it was after she walked away that he followed her. When police had contact with him, he denied driving his mother's vehicle. When police had contact with him at his house, he ignored their commands because he was found in the vehicle, claiming that he was having an anxiety attack upon the sight of the squad car and needed to get into the home to get his inhaler. When I say the rules don't matter to Mr. Brooks and court orders mean nothing, Mr. Brooks was in custody, and there are jail phone calls where he's berating Erica Patterson, encouraging her to recant, blaming her for what had happened, saying things on that phone call like, "You trying to make it seem like everything is always everyone else's fault but yours. Like you don't never do anything to cause shit. And the whole cause of this shit was something that you fucking did." He ended the call by telling Erica Patterson, "You did this shit, and you couldn't even keep your mouth shut after numerous people told you that shit. This ain't the place for you to be doing this shit, and you still ran your mouth. And I'm the one sitting in here facing all this time." He repeatedly calls her a bitch. During a phone call on November 11th, Darrell Brooks is overheard or captured saying, "Why in the hell would I just try to mow her down knowing I could kill her like that? Like, okay, I probably got a few screws loose, but I ain't hardly no goddamn fool." He's complaining that she won't help post his bail. "You didn't put a cent on my bail. Why should someone else have to pay for some shit you caused?" The end, apparently, of that conversation, or at least moments later, he says to her, "Nah, I didn't try to do anything, because if I tried to do something, you wouldn't be on the phone now. That's what you're not realizing. If I really tried to do something, you wouldn't be on the phone now." That is the rage and the anger that Mr. Brooks had on November 21 of 2021 when he tracked down Erica Patterson, confronted her. This wasn't about him getting money from her, like he lied to Detective Carpenter about. This was to confront her. He clearly hit her, we know that. This is the type of man that drove through the Christmas parade, enraged because, frankly, it's entirely possible that Corey Runkle and Nicholas Kirby saved the life of Erica Patterson. It's clear Mr. Brooks was hell-bent to cause harm to her, but she was able to get free, run back to her friends. Who knows what would have happened but for their intervention. If you think back to the testimony of Nicholas Kirby, he felt bad for threatening Mr. Brooks, like somehow this was his fault. He was just trying to be there for his friend, someone he recently met. So Mr. Brooks, that other act's evidence is a very clear indication of your poor moral character. It demonstrates unequivocally that you have absolutely no remorse for anything that you do. You have no empathy for anyone, and that you are justified in the actions that you take. In addition to that conduct, as part of your character, this court is able to look at and consider your prior record. And I'm well aware, sir, that you're raising an objection sign, but you have forfeited your right to be here, and I will not stop, and you will not be brought into this courtroom. I will continue. This is his prior record, going back to two thousand. Spanning what? Nevada, Georgia, at least police contact in Georgia. We have an unknown disposition, and Wisconsin. Substantial battery in 2000, party to a crime. Put on probation, ultimately that was revoked, he went to prison. 2002, felony possession of THC, jail time. 2003, resisting obstructing jail time. 2005, a disorderly conduct ticket, but he failed to pay the forfeiture and ended up serving an alternative to incarceration. Sorry, he ended up serving for failing to pay 30 days jail. 2009, obstructing 2 days jail, meaning he lied to police. 2010, strangulation. Battery was dismissed and read in, put on probation, ultimately revoked, serving 11 months jail. 2012, misdemeanor bail jumping, possession of THC, with a number of other charges being dismissed and read in, 180 days jail concurrent. Also in 2012, a misdemeanor resisting or obstructing, so either he lied or he fled from police or did something to make their job more difficult, 37 days jail consecutive. In Nevada in 2006, domestic battery, a suspended sentence, obstructing after being found guilty at trial, for which he served jail time. 2007, statutory sexual seduction as a felony. This is for impregnating Erica Patterson when she was a minor. 2016, charged with not being in compliance with the sex offender registry requirements, for which there is an outstanding warrant. In Georgia, a 2021 arrest for battery, domestic violence, presumably with Erica Patterson based upon where she came from at that time. But I won't make, I say presumably, but frankly doesn't matter who it was with. We also know that there's the 2003 paternity case out of Waukesha County. Why is that relevant? Because 8 times during that case, a warrant has been issued for contempt of court, meaning for failure to pay his financial obligations to a child or children. The pending cases for which one pending case, I should say, he was, I don't believe, charged with bail jumping for that one. The 20 CF 2550, 2 counts of recklessly using a weapon, felon in possession of a firearm, released ultimately in March of 2021. He's accused in that case of firing a shot. There were two occupants in a vehicle. One was his nephew, and when he was picked up by police, a loaded Beretta, 9mm, which had previously been reported as stolen, was found in his possession. I already talked about the other acts evidence, that is for which he was charged with felony bail jumping, the second-degree recklessly endangering safety for allegedly running over Erica Patterson, the battery DV, DCDV, and a resisting obstructing. And then the second would be he was charged with intimidation of a victim, felony bail jumping for conduct on November 8th. So November 2nd, November 8th. This is clearly someone with a demonstrated violent history and past, someone who has absolutely no regard for anyone but himself. To say that he is a lifelong criminal, I think is accurate. He disobeys law enforcement, he disrespects court orders, and he certainly demonstrated that he has no respect for these proceedings. Multiple acts of violence, violent, dangerous behavior that predated the attack on the Waukesha Christmas parade. His character, or lack thereof, is also demonstrated by his complete and utter denial of culpability in this case. His blaming of his mental health or alleged mental health. There's no evidence that he was suffering from a manic episode. I went through all of that earlier today, going through the 4 reports related to the special plea. None of those doctors found support for his special plea. Mr. Brooks talked about at times this being the will of God, or that all things happen for a reason. I'm here to tell you, Mr. Brooks, you are not an instrumentality of God. Death may be inevitable to all of us, but you cut the lives of 6 individuals short. You alone, Mr. Brooks, cut the lives of these 6 innocent people short. I talked earlier about how I believe he's intelligent, deliberate, and purposeful in what he does. I've considered that you have treatment needs. Perhaps there are intersecting mental health issues as it relates to your personality disorder, but those issues can best be addressed in a confined setting where the Department of Corrections will be charged statutorily to evaluate you and to provide any medical or mental health treatment that you need. This is a case that falls squarely on the need to protect the community. I referenced this earlier. There's really 3 primary reasons for the sentences I will impose here today. One is punishment, one is to protect the community, and the other is to provide justice and closure to the victims. Because under that category of need to protect, the court does get to consider the impact of these crimes on the victims. I went through at length in reviewing all of those victim impact statements. I certainly didn't go through every single one, just highlighting some of them, but doing so with purpose, because it is very clear to this court that Mr. Brooks has caused carnage, mayhem. It has resulted in many people suffering from PTSD, from mental and emotional trauma that will take a lifetime to recover from, and for some, perhaps, if at all. You have taken away from these individuals future memories. They will never have birthdays with the 6 individuals who were killed. There will be no weddings. There will be no graduations. There will be none of the milestones that these families were looking forward to, whether it be for an innocent 8-year-old or an innocent 79-year-old. Frankly, Mr. Brooks, no one is safe from you. This community can only be safe if you are behind bars for the rest of your life. The actions of Darrell Brooks demand punishment. The community is not safe from your violent and criminal conduct unless you are in custody. You left a path of destruction, chaos, death, injury, confusion, and panic as you drove 7 or so blocks through the Christmas parade, never once stopping or seemingly caring about the wake of carnage that you left. 4 of those blocks were turned into a scene that frankly is no different than a war zone. On counts 1 through 6, this court is imposing a life sentence without the possibility or eligibility for extended supervision consecutive to one another. 1 life sentence for Virginia Sorensen. 1 life sentence for Leanna Owen. 1 life sentence for Tamara Durand. 1 life sentence for Jane Kulik. 1 life sentence for Bill Hospel. And 1 life sentence for Jackson Sparks. I've considered the enhancer and the additional 5 years that I could impose, but I don't need to really order that because I've not made him eligible for extended supervision, and it would only be to increase his time on initial confinement. But make no mistake, Mr. Brooks, you use that vehicle as a battering ram, no different than, frankly, a firearm. On counts 7 through 67, these are 61 counts of first-degree recklessly endangering safety. These charges alone and these convictions without the enhancer carry a maximum of 12.5 years. Because of the enhancer, a total of 17.5 years. And under Wisconsin law, the 5 years is added to the initial term of confinement. So what could be 7.5 years is a maximum of 12.5 years. And I'd ask that everyone no longer show any reaction to the sentence so I can get through this. On counts 7 through 67, on each count, I will impose a total sentence of 17.5 years. 12.5 years of initial confinement, plus 5 years of extended supervision, consecutive to any other sentence that I've imposed here today. That is 762.5 years of initial confinement and 305 years of extended supervision on top of the life sentences that I've imposed. That is 17.5 years, sir, for Nicole White. 17.5 years for Eleanor Anders, 17.5 years for Sasha Catalan Castillo. 17 and a half years for Maura Gilchrist. 17 and a half years for Justin Gullickson. 17 and a half years for Harry Guilfoy. 17 and a half years for Aiden Lofgren. 17 and a half years for Theo Mazza. 17 and a half years for Tyler Pudliner. 17 and a half years for Connor Tank. 17 and a half years for Eric Teagues. 17 and a half years for Adelia Maffioli. 17 and a half years for Kelly Graybow. 17 and a half years for Josh Craner. 17 and a half years for Riley Rogers. 17 and a half years for Caden Rogers. 17 and a half years for Tucker Sparks. 17 and a half years for Isabella Bartlett. 17 and a half years for Yaritzi Becerra Montez. 17 and a half years for Samantha Coelho. 17 and a half years for Madison Hollingsworth. 17 and a half years for Mackenzie Hollingsworth. 17 and a half years for Mitchell Lampine. 17 and a half years for Kathleen Pielmeyer. 17 and a half years for Julia Schleichow. 17 and a half years for Olivia Stover. 17 and a half years for Jennifer Stover. 17 and a half years for Jesselyn Torres. 17 and a half years for Alice Urell. 17 and a half years for Charlotte Urell. 17 and a half years for Vivian Urell. 17 and a half years for Grayson Urell. 17 and a half years for Lola Hospital. 17 and a half years for Tamara Rosentreter. 17 and a half years for Betty Strang. 17 and a half years for Maria Alvarez Dominguez. 17 and a half years for Gregoria Romelia Perez. 17 and a half years for Elliot Hallmark. 17 and a half years for Benjamin Hallmark. 17 and a half years for Patrick Heppy. 17 and a half years for Lori Locken. 17 and a half years for Marisol Lopez Gutierrez. 17 and a half years for Adair Lopez Rubelar. 17 and a half years for Juan Marquez. 17 and a half years for David Marquez. 17 and a half years for William Mitchell. 17 and a half years for Jason Petchloff. 17 and a half years for Margaret Pachulis. 17 and a half years for Yamilet Perales Alvarez. 17 and a half years for Island Perales Alvarez. 17 and a half years for Ashley Perales Alvarez. 17 and a half years for Jose Perales Alvarez. 17 and a half years for Maria Perez. 17 and a half years for Camila Perez Gonzalez. 17 and a half years for Isaac Foglia. 17 and a half years for Deborah Ramirez. 17 and a half years for Charles Green. 17 and a half years for Lily Green. 17 and a half years for Brinley Harris. 17 and a half years for Kelsey Knapp. 17 and a half years for Owen Ricciati. On counts 68 through 73, which are the 6 counts of hit and run resulting in death, these are 25-year felonies each. The court will do the following. On count 68, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision. This will be concurrent to count 1. Count 69, the same sentence, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count to count 2. Did I say that the right way, the first one? Okay. Count 68 is concurrent to count 1. Count 69 is concurrent to count 2. Count 70, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 3. Count 71, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 4. Count 72, 25-year total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 5. And on count 73, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 6. On count 74 and 75, the 2 felony counts of bail jumping, the court is ordering a 6-year sentence total on each count, 3 years of initial confinement, 3 years of extended supervision, consecutive to all other counts but concurrent with one another. And lastly, but certainly not least, the maximum sentence for the battery to Erica Patterson, 9 months consecutive to any other sentence. To order anything other than what I have done, sir, would be to unduly depreciate the seriousness of these offenses. It is needed, although largely symbolic, given the number of years that I have imposed here today, because frankly, you deserve it. I know it's symbolic, but it needs to hold you accountable in a very real and tangible way. For all of these sentences that I have imposed, I will order the following conditions: no contact with the victims as identified in the amended victim key or their families, no contact of any kind with Erica Patterson. You are to pay restitution in the amount of $47,193.29 to EMC Insurance Company, that's on behalf of the Waukesha School District, and $124,000, $220.65 to the Crime Victim Compensation Program. I am ordering DNA surcharges on all counts. On counts 1 through 75, it's $250. On count 76, it's $200. Those are mandatory under the law. I'm also imposing the domestic abuse surcharge on count 76 of $100. I'm also imposing all standard court costs on all counts. Although my primary emphasis is that restitution be paid before costs, surcharges, and fees, I will order that restitution, costs, and fees be paid out of prison money. In other words, that all financial obligations shall be collected pursuant to statutory provisions as requested by the state. That's frankly a standard, it's customary, but it will be in the judgment of conviction. And then pursuant to 949.165, I'll find that it is appropriate for this court to order an escrow account under 949.165 for payment of restitution, costs, fees, surcharges, and even for costs associated with prior legal representation or future representation under the statute. Mr. Brooks has been convicted of a number of serious crimes for which this section is appropriate. I will order 360 days credit as to count 1 and count 68. Only, all other counts, 0 days credit because of the consecutive nature of the sentences that I've imposed here today. I calculated that with my sentence calculator. Of course, that is through yesterday because these sentences commence today. There are a number of advisements I must go through. First of all, Mr. Brooks will be provided with a written explanation of determinate life sentence regarding the first-degree intentional homicide charges. Of course, he's not eligible for release to extended supervision. That form defines extended confinement for him, and there's other language on here that he can read at his convenience. He also will be provided with the notice of right to seek post-conviction relief form. The court will fill out the caption for him. He is instructed to review it. and review the defendant's acknowledgement, make the appropriate selection, sign and date it, and return that to the court. I must advise you, sir, you have been convicted of a felony. That means you may not vote in any election until your civil rights are restored. You may not possess a firearm. You may not possess body armor. Both of those are punishable as felonies. You also have 20 days from today's date to appeal the decision of this court. Does the state believe I've overlooked anything here today?
No, thank you, Your Honor.
All right, those documents will be provided to Mr. Brooks. I will note for the record, at many times during my final sentencing remarks, he was holding up an objection sign. That objection is noted for the record. This now concludes this hearing and this case. We are now off the record.
Do you want to do the motion to stay pending appeal, or we could do it another
I want to
day?
wait till I sign the judgment of conviction. I'm not making any determinations regarding where he is to be held. That certainly is within the, once the judgment of conviction is signed, I'll address the motion for stay pending appeal. But my understanding is he needs to be transported to Milwaukee, and I will not stand in the way of that. All right, I'll schedule that once the judgment of conviction is signed.
Understood.
We are in
Thank you.
recess.
Okay.
Thank you, everyone. Thank you.
They're still going to come back. She said we're at recess, right? Or does that mean it's over? Yeah, you got to show us taking him away.